G'day, Year 11. So I just wanted to go through what I think is an example of the assignment. Exactly the same topic you've got. Of course, we've all got some scope to choose what we're looking at. But as well as talking through, I'm just going to talk about a couple of things as to why I've done them. I've done it in a slightly different format, just because I don't want there to be any concerns about you taking ideas and feeling that you can't use them because it's the same format. So just by keeping it a different format, I think it keeps it different enough that you can use the ideas without having to worry at all about copying. So the topic we're looking at is statutory protection for people in the sharing economy whose contracts are frustrated. We're specifically looking at Airbnb during COVID border closure. So what happens if you've booked an Airbnb accommodation and the booking can't go ahead because there's a COVID breakout either where you are or where they are and borders are closed. So now this is effectively the scope and sequence of what we might consider. So we're looking at three different things here. The role of the ACCC, we're looking at the idea of frustration in contracts, and we're looking at an analysis of what a COVID border closure means related to a contract, because there's legal force behind that COVID border closure. So let's start with the Competition and Consumer Act 2010, which sets out Australian Consumer Law Section 2. And we're particularly looking at Section 61, which is fitness for purpose for a service. So that's the idea that a supplier has to guarantee that a service will reasonably fit the purpose. So in this case, we're thinking about how does that relate to a booking that's booked on a certain period of dates? If those dates can't go ahead and they have to be changed, does that still leave a service that's fit for purpose? Right, why the ACCC? And the ACCC is a statutory body that supports consumer protections, gives consumers often the power because it's hard for them to act individually. And this is something that works across state lines. So even though there's something like the Fair Trade Practices Act in Queensland, a national body is more appropriate for something that works across state lines. So now we look at the second issue, which is frustration in a contract. We looked at this precedent case from way back in 1863, where a hall burnt down and a hiring of the hall couldn't go ahead. So Justice Blackburn, in putting together his decision, established a doctrine of frustration by saying that when there's a contract, there is a condition that is implied where there's an impossibility of performing a task. And so the possibility of performing a task, impossibility of performing a task in this Airbnb is saying, well, if you've got border closures that don't allow you to travel, you can't go and take advantage of the accommodation you've booked. Legal author Julie Clark also talks about it in Australian context and says that it's an event that renders the performance of the contract as fundamentally different than anticipated. So here we're thinking, does a border closure make a contract fundamentally different than anticipated? So our core legal issue is this: should the ACCC extend Section 61 of the Australian Consumer Law to specifically include the issue of frustration in accommodation bookings in Australia? I should say too, it wouldn't be, I probably made a mistake there, it wouldn't be the ACCC that extends 61. It would be the legislation. So should legislation mean that the ACCC can extend their involvement in the issue to look at the issue of frustration in accommodation bookings in Australia? So let's think about the stakeholders. And I've gone here to a stakeholder from this article down the bottom on the website 9.com.au as a case study. Nita Burgess, she had an Airbnb booking, Sydney lockdown. Now, Sydney lockdown's worth mentioning. They come from, there's a legal force behind them. They're part of a public health order. And so the New South Wales Health Minister has made this order that people can't travel under Section 7 of the Public Health Order 2010. She hasn't been offered a refund. She's been offered an alternate midweek stay, which is very different from what she's booked, and there's $3,000 at stake. Another stakeholder that's important is Airbnb. Now, interestingly, they have a specific policy where they say that COVID is no longer considered an extenuating circumstance. So that sort of extenuating circumstance that would lead to a contract being frustrated, because after this time in March, we're all aware of COVID. We all know that can interrupt things. And we've got this article here from The Guardian that we would have used as a reference if it was a written thing, just talking about Airbnb changing their refund policy. So, Airbnb, if we think about things from their perspective as a key stakeholder here, they've been clear with their communication and policy, their behaviour is consistent with their policy. Now, COVID-19 is no longer unknown, and equally impacts are, if not specifically foreseeable, but we can see there's likely to be border closures and things. And so this leads us to the first legal alternative. The first legal alternative is that the current legislation is reasonable and there's no need for any intervention. Now, remember, with the legal alternative, we only have to state it. We don't have to go into depth about it, but we do have to link it to our analysis, which I think I've done reasonably well there. Okay, this isn't the best set out slide, but let's carry on anyway. Now, we now come to this question: has a contract been frustrated through a government travel restriction? How should we deal with this set of circumstances? From our analysis previously, we said there's two elements that we consider in discussing frustration: impossibility in performing the task, so that would be in this case going and attending the competition, and the performance of the contract is something fundamentally different from anticipated. So if we think about those things, along with the ACCC definition of service delivery, whether it's fit for purpose, we can probably say that when there is an outbreak outside of a person's control, that we could say that there is now an impossibility for that person to go and take advantage of the accommodation as the first point. We can then look at the second point and say, well, it is different to anticipate that person anticipated being able to travel. And if we think about fit for purpose, we'd say, well, you know, the accommodation was there on those days, and so there is an argument that it's no longer fit for purpose, it can't be accessed at that time. So this leads us to our second legal alternative, a statutory acknowledge of frustration in fairly extreme circumstances, and we define what we think by extreme circumstance here. Okay, so key element is to try and quantify the extent to which a person is prevented from participating in the contract. So we talk about, here we propose a benchmark that could say, well, when it becomes illegal to participate through no act of an individual. So this takes into account that someone might do something silly and have to go to court or something like that. Well, that doesn't count because they've done it themselves. But if there's something outside of their control that becomes illegal, such as a border closure where they can't travel, then we would say make it explicit that the contract is considered frustrated, and we could amend Section 62 of Australian Consumer Law so that the service is no longer fit for purpose. So we're specifically looking at that section and changing the definition. In the context of COVID-19, this would include situations of border closures, movement restrictions, or if you had tested positive and you had to compulsorily quarantine for a period of time. So let's think about this legal alternative from the Airbnb owner's perspective. So not all of the service has been frustrated, so we can perhaps be more sophisticated in our recommendation by saying that the service provider has spent some time in organising a booking and putting the accommodation, maybe some advertising, some communication. So then we could put a benchmark that says, well, let's consider that and allow 20% of the total booking value to be kept by a service provider as acknowledgement of partial completion of the contract. So now we come to the idea, is it fair and just? Part of any recommendation we have to change, and we also think about the third part, which is what are some implications. So let's think about it from the perspective of the two people and use those two people involved in the situation as a measure of whether it's fair and just. So Ms. Burgess, she would receive an 80% refund on a holiday. She can't participate because her health order is outside of control, and she's compensated by the return of the majority of funds. So that seems to be a situation that is fair. The Airbnb owner, they still receive compensation for the activities involved in booking the holiday, so they have spent some effort there and they're compensated for that in the 20% acknowledgement. And they are in the position where they may be able to, I guess it's hard to know given we don't know the whole situation, they may be able to re-advertise the accommodation for a lower price and find alternate guests. For example, people who live in the area. And in the specifics of this case, when it was accommodation outside of Sydney, I think that would actually be possible knowing the facts. And lastly, we think about the implications for community and consumers. So one element from the community perspective is that if Ms. Burgess wasn't getting a refund, there's a chance that she could be tempted to try and ignore the health orders and travel and get some value, which increases the risk of some spreading of COVID or whatever the reason is behind the restriction in travel. So that's a negative that's overcome by the fact that she's got a better outcome from this situation. And also consumers then have confidence that that they can have a confidence that if it becomes illegal to enjoy the contract, and we're talking about accommodation here, through no fault of their own, there is now a better definition of what is fit for purpose in the services that the ACCC have the authority to enforce. They can go ahead in that. But it's a fairly high bar. So we're talking about something that would make it illegal. And so that makes it fair in terms of the Airbnb owner would only be impacted by fairly unusual occasions.